This is American Government on Friday, November 6th. Thank you. 2020, we're discussing the judiciary. And this will take us over the next several lectures. This is the last major institution in American life that we'll be examining, and we'll follow the same procedure. We'll look at original intentions in design, historical development, and contemporary controversies. We'll see that in addition to looking at the original design for the judiciary, we'll look also at the initial appearance and this will be on Monday the next lecture, when we consider Marbury v. Madison, the great case in which the first great Chief Justice of the Supreme Court, not the first Chief Justice, but the first great Chief Justice, John Marshall, appointed in 1801 and who served for 34 years, more about that on Monday, announced the doctrine of judicial review. And in my notes for today, on the second page of the notes, and this is also in Wilson, which is a very good chapter on the judiciary too, and also has a good discussion of the case, Marbury v. Madison, which you should refer to for Monday especially. What is judicial review? I define it on the second page. Basically, the power of the courts to declare the acts of Congress and the President and the states unconstitutional. So literally, judicial review refers to the power of the courts to use the Constitution as a legal standard in deciding cases. That's how we'll see Marshall defines it in Marbury v. Madison on Monday, or the next lecture. But basically, the power of the courts to declare, to review and declare the acts of the other parts of the constitutional system unconstitutional. Now, we'll see that one interesting thing about the founders and the judiciary is that there wasn't much said about the judiciary. There's Article 3, of course, but in the Constitutional Convention, there wasn't an extensive discussion of the judiciary as there was in the case of Congress or the presidency. You might say that in some ways, well, let's talk about that. Why was the Constitutional Convention relatively silent about the construction of the judiciary? We will, as you'll see, we'll look at a small excerpt from the Constitutional Convention on the question of judicial review. But you could say that the reason they discussed Congress so thoroughly is they had to discuss the nature of the Union, and then they had to construct the national legislature in such a way that reflected both the Union of the American people and we the people, which is in the House, and the Union of the States, which is in the Senate, the Great Compromise. And it would make sense that they also had to discuss so much of the presidency because they were constructing this new branch. And it's true that the Articles of Confederation didn't have a judiciary, but all the states had judiciaries. And you could say this, that much of the way that we understand our judiciary to be constructed and operates comes from the English common law judiciary, the British judiciary, and that therefore they assumed that, and this was true in fact, that much of the structure and processes of the British judiciary would become ours. And by and large, that is true. As we'll see over the next couple of sessions. So let's look at the sole excerpt from and almost the only discussion of the judiciary in the convention. And what's more is you'll see that this is an interesting anticipation of judicial review in the Constitution. Now, by way of preface, let me just say that since we just mentioned the British judiciary, many of our practices, well, let me back up. When I say structures and processes, the whole notion of the hierarchical, the pyramidal judiciary with local or district courts, Wilson will explain this in chapter 12 very nicely, and then intermediate appellate courts where cases are appealed from lower courts and from localities. So the hierarchical structure, again, that we'll come back to in Wilson, essentially means a lowest level of courts, which are also local courts, district courts. And then there's an intermediate level of courts, which are called circuit courts, because many times the judges of the Supreme Courts would ride circuit, but also appellate courts. And then at the top of the period is a Supreme Court. Now, it's a little fuzzy in the British Constitution what that Supreme Court is. That's actually the House of Lords. But at any rate, the framers decided to follow the same kind of a pyramidal model when they constructed the federal judiciary, as did most of the state courts when they constructed theirs. Many of the processes and writs are all the same, like a writ of warrant, a writ of habeas corpus, a writ of mandamus, which will be important in Marbury v. Madison, and many of the practices such as stare decisis, precedent, treating as an authority the precedent decision of an equally authoritative or higher court. So, with that in mind, let's look at the excerpt from the Constitutional Convention regarding the judiciary. And here's a little bit of background. Remember that Madison in Federalist 51 argued that Republican government would always present the danger of legislative tyranny. Obviously, tyranny, as you saw from our consideration of the founding and from Federalist 51, tyranny could come from any branch of government or the people itself, as it says in Federalist 10. So, but Madison thought in Federalist 51 that the legislative branch would always present the danger of trying to escape from constitutional bounds. Constitutionalism means, in particular in this respect, containing the power of the legislative branch within constitutional limits. And that would require more than just stern wording in the written Constitution, which, by the way, Madison complains about. And in the earlier segments of the section where he deals with the separation of powers and checks and balances, Federalist 47 through 51. Remember, 51 is the last paper in that sequence, and the culmination of it. He refers to the state constitutions, which all had separation of powers and limits on the legislative authority, but the state legislatures just trounced them and didn't care. Madison calls these parchment barriers. They were constitutional restrictions on legislative power that didn't work in practice. They only existed on paper, parchment, of course, at that time. So obviously, to keep the legislature in check, this would require an external force sufficient to the task of resisting the voracious legislature. At this point in which he composed the provisions of the Virginia Plan, remember he was with the 7 people from the Virginia delegation. They had gotten to Philadelphia in May of 1787 on time, and they had the week before the rest of the people got there, and the convention opened up on May 25th. So Madison drafted the Virginia Plan, and he had Edmund Randolph, as you remember, present the Virginia Plan on the third or so day of the convention on May 29th. But at that point, even though he knew that there had to be, in many ways, a strong executive, he wasn't as strong executive person as Hamilton was, he could not conceive of either the executive branch nor the judicial branch possessing such power alone. And so in Resolution 8 of that plan, you can look in the Nichols Reader again, he proposed a council of revision, a constitutional court or body, which would combine the function of the veto, the presidential veto, and judicial review. Here's that provision, number 8 in the Virginia Plan. Resolved, that the executive and a convenient number of the national judiciary, he conceived of a body of either the president and perhaps senior members of the executive department and the courts, or at least the Supreme Court, ought to compose a council of revision with authority to examine every act of the national legislature before it shall operate, and every act of a particular legislature of the states before a negative thereon shall be final, and that the dissent of such council shall amount to a rejection, unless the act of the national legislature be again passed, or that of a particular legislation again be negative by X members of each branch. The convention then, as they moved to the provisions of the Virginia Plan, took this up, and here's the discussion of it. Mr. Gerry, Elbridge Gerry, doubts whether the judiciary ought to form a part of it, that is to say, the Council of Revision, as they will have a sufficient check against encroachments on their own department by their exposition of the laws, That is to say, the function of judges is to interpret the laws, and Jerry is arguing they don't need to be part of this executive council because they'll already have the power to examine the constitutionality of laws as they interpret and apply and lay out the law in exposition. In some states, the judges had actually set aside laws as being against the Constitution of the state, that is. This was done, too, with general approbation, although very rarely. And it was not universal. And so this is really one of the first discussions, first mentions of the idea that the courts would have this power. It was quite foreign from the nature of the office. It says ye there. Remember, ye, as we pronounce it, was actually the Y there was actually a substitute for TH in older English. The office to make them judges of the policy of public measures. He moves to propose the clause in order to propose that the national executive shall have a right to negative any legislative act which shall not afterwards be passed by blank parts of each branch of the national legislature. Just a couple of words of commentary. Jerry is saying, you don't need to create this special constitutional branch to consist of the other two branches to restrain the legislature through the power of negating or vetoing laws or rejecting laws. The executive is going to have that anyway. Indeed, that is at least part of the Constitution's solution to this issue. At the time, at the beginning of the convention, remember, the Madison included, didn't have a sense of how strong and energetic, to use the founder's term, the executive would have to be. So he says, but actually, the executive will have that power. And remember, the reason the executive power in the U.S. Constitution is so powerful is because it's, interestingly enough, not absolute. I mentioned, I believe, earlier in discussion in the presidency or in the Constitutional Convention that the British Crown has a veto power over the laws of Parliament, but it's absolute. It's the qualified veto, with the Congress's ability to override a presidential veto with 2/3 of an acceptable vote in both houses, that actually constitutes a strengthening of the presidential veto, because it's less absolute and therefore more employable on a regular basis. Now, the interesting thing in Jerry's comment is, he says, they don't need to participate in this body, the judiciary, because they'll already have the power to review legislation for constitutionality when they interpret it and apply it in cases. That's in essence what he's saying. So the truth of the matter is, this comment didn't generate a lot of extension or comment. You could say that it did lead to the presidential veto, as I just mentioned, and as we'll see, it also led to a kind of judicial review that is explicit in the Constitution, and that is in Article 6. Look on the second page of the notes from the part that I've already read under B1, and let me just continue that, and then we'll skip that when we come to this in a minute. Some form of judicial review is mentioned in the Constitution, as if you remember from our intensive examination of the Constitution, in Article 6. The enforcement mechanism of constitutional and national supremacy is, quote unquote, the courts in each state, which will declare void any provision of a state law or constitution that conflicts with the Constitution or a national law or treaty. That is to say, the framers, and just to contextualize this from our discussion on the Constitutional Convention and the creation of the Constitution, remember that everybody that came to the convention in 1787 knew there had to be some kind of enforcement mechanism of the national government against the states. The Articles had lacked that, and that was a major problem with the centrifugal power of the states pulling the national government and weakening it. There was no power of the national government to enforce either the Articles of Confederation or the laws of the Union against the states. Remember, and Madison's solution in the Virginia Plan was this Council of Revision. If you remember, in the New Jersey Plan, which was essentially the Articles, that plan called for the calling out of the military power of the Union against a recalcitrant state, and that was rejected. Madison, I'm sorry, I misspoke myself a minute ago. The Council of Revision that Madison is talking about, and that we just discussed, has nothing to do with he does actually give the power to look at the states. but it's essentially part of the separation of powers and checks and balances, the three branches of the national government against itself. And by the way, that's what the Constitution is silent on. The Constitution is absolutely silent on the question of whether the court, the Supreme Court or the Judiciary, can nullify, review, and reject or nullify acts of Congress and the President. That is an implied power in the Constitution, not explicit, as it is against the states. Remember, what Madison wanted in the Virginia Plan, which was also rejected, is that he wanted the Congress to have the power to review and reject, negate all state legislation, which that was rejected, if you remember, on the grounds that that would be too burdensome for Congress. Congress would be involved in national legislation, and that, and again, think of how the Union has expanded since then with 50 states. If the Congress had to review the legislation of every one of the state legislatures, then it would never have time or ability to govern in the interest of the nation. So, so the enforcement mechanism against the states, and here you might remember my fascinating mathematical equation, which was an attempt to put in absolutely succinct terms the nature of the Constitution. C equals VA to, that is to say, the Hamilton and the in Article 2, the strengthened. Oh no, excuse me, I forgot my own equation. C equals VA, and then the Senate, the Great Compromise, the S, plus H2, Hamilton's, the strong executive from Hamilton's plan, all over JR, and the JR stands for Judicial Review. That's Article 6. But again, let me say then, on the question of this kind of review power over the other two branches of the national government, the Constitution is silent. And again, that has to be implied or inferred, which is what, as you'll see, in a way Jerry was doing in this comment we just read. And it's what Hamilton will do, and the bulk of today's lecture will be to walk through the argument that Hamilton presents in Federalist 78. And by the way, following the outline of the Federalist Papers that we looked at earlier, the consideration, the presidency goes from 67 to 77. And so from 78 to 83 is our Hamilton's essays on the judiciary. And this is, so Federalist 78 is to the judiciary, as Federalist 70, etc., is to the presidency that we looked at, and etc. So let me introduce that overall and explain what he's explaining. And you'll see that within this essay is the first true extended theoretical discussion. Hamilton is really the first profound theorist of judicial review into the Constitution, even though it was very briefly mentioned, as we saw, by Jerry in the convention. So Hamilton argues that, and so what is the original intention? If energy in the executive is what Hamilton thought the executive branch needed, again, here Polvorty, the political scientist, is coining a term for you. The quality that he is defending and arguing that what the institutional quality that the judiciary needs to be constructed according to is stable independence. Now, it's because courts are about justice, and to have justice, you need impartiality. But to have the judge above the two parties in a case to be impartial, which is what I mean. If the judge isn't impartial and is biased, then you can't have justice coming out of the court. And remember, justice is the core purpose of the court, of a court. So without impartiality, no justice. And then the institutional quality. Remember, this is a parallel to the argument that Hamilton makes in 70, etc. The executive needs energy for these purposes, those four tasks. What are the institutional ingredients of executive energy? Unity, duration, adequate support, and competent powers. That's just a review, if you remember, from a couple of weeks ago. But the judiciary, whose function is justice, requires impartiality. So how do you construct the judicial institution to possess that stable independence? And and of course, it's in the matter of appointment. Now, for the separation of powers, Hamilton points out that, strictly speaking, you should have each branch selected independently. Hence, the people elect the Congress in the states. Now, the people, through the 17th Amendment, elect the Senate and the Congress. The Electoral College, the people, through the Electoral College, elect the president. But the judges of the judiciary have special qualifications, so popular election wouldn't be the best way to appoint them, and so they have to be appointed. But to make sure they are independent, you have two branches participate in it, the president and the Senate, which we just saw happen recently. But the main ingredient in judicial independence in the judicial institution is appointment for good behavior, lifelong tenure. And it's worth reading an extensive excerpt from Federalist 78 in the Nichols Reader, where Hamilton explains this. According to the plan of the convention, this is Hamilton and Federalist 78, or on the judiciary in the Nichols Reader, all judges who may be appointed by the United States are to hold their offices during good behavior, which is conformable to the most approved of the state constitutions, and among the rest to that of this state. Remember, he's writing in New York when he says this state, which is where the Federalist Papers were addressed initially. Its propriety, its appropriateness, its propriety having been drawn into question by the adversaries of that plan, is no light symptom of the rage for objection, which disorders their imaginations and judgment. That's a hit at the Anti-Federalists. The standard of good behavior is the continuance in office of the judicial magistracy. It's certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is no less an excellent barrier to the encroachments and oppressions of the representative body. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. And then let me continue in the next paragraph or so, because it's a general meditation on the power and nature and role of the judiciary in a written constitution, a permanent written constitution, and also how the judiciary ranks as a branch among the three separate and co-equal branches of government. Now you're going to see that this is setting up the argument for judicial review, and I'll make that clear in a second. To continue with Hamilton, whosoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, to the nature of the overall constitutional framework, because it will be least in a capacity to annoy or injure them. The executive not only dispenses the honors, the appointments and honors, but holds the sword, the force of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, so the executive is a threat to the constitutional system because it can arrest you and has guns. The legislature can be a threat to the constitutional system and the separation of powers because it prescribes rules. Congress, after all, creates the other two branches besides what's in the Constitution, and has the power of the purse. It can command money. The judiciary, in the contrary, has no influence over either the sword or the purse, no direction either of the strength or wealth of the society, and can take no active resolution whatever. As we're going to see what he's saying here, and this is a part of our the idea in the Constitution is that the courts can only act when other outside parties bring a case to them. That's because in Article 3 it says the judicial power shall extend to all cases and controversies which shall come before the court. So the court can't act independently. It can't, whereas the Congress can pass any law at once at any time at once, subject to its limitations, and the executive can act at any time under its own discretion. The courts are passive. they can only exercise judicial power when some outside parties bring a conflict to them, and they are confined to a case in terms of exercising that power, and can take no active resolution whatever. It may truly be said to have neither force nor will, the judicial or the judicial branch, but merely judgment, that is to say, interpretation of the laws, etc., and must ultimately depend upon the aid of the executive arm, even for the efficacy, the enforcement of its judgments. So when a judge sentences, or a jury sentences somebody to a jail term, the judges don't hop over the bench and grab the person by the shoulder and drag them off to the prison. The judges are, in criminal cases, for instance, the judges are dependent upon parts of the executive branch, the prosecutors or attorneys general, to bring the case and prosecute it. And once sentence is passed, they're dependent upon the executive branch to enforce the sentence. So Hamilton is saying of all the three branches, that the judiciary is the weakest. This simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. Now, let me go forward a couple of paragraphs, and he continues this. So this complete independence of the courts is necessary, first of all, because it tends to be the weakest of the three branches. But to continue a little bit further on down, the complete independence of the courts of justice is particularly essential in a limited constitution. And you're going to see Chief Justice Marshall in Marbury v. Madison in our next lecture will rely heavily on this essay for the core argument in Marbury v. Madison. By a limited constitution, I understand one which contains specific exceptions to or limitations upon, that's my paraphrase for what he means, the legislative authority. Such, for example, as it shall pass no bills of attainder, no ex post facto laws, and the like. And by the way, that is in fact, those two limitations are mentioned in Article 1, Section 9 against the National Congress, and in Article 1, Section 10 against the state legislatures. Limitations of this kind can be preserved in practice by no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor or spirit, and that's what tenor means, of the Constitution void or null in effect. Without this, all the reservations of particular rights or privileges would amount to nothing. So without an independent and strong judiciary and to enforce the limits of the Constitution on both legislative and executive power, the constitutional system would not be in place, would not be stable and limiting. We wouldn't have limited government. We'd have unlimited totalitarian government, and the rights of individuals would not be secure. And by the way, let me just say this with respect to this point. He's right. The Soviet Constitution of 1936 listed all kinds of rights that make our Bill of Rights seem like the Dollar General version of Bills of Rights. But it's clear that the Soviet government had a massive and uncontained tyranny over its citizens because, of course, it had no independent judiciary. There is real substance to what Hamilton is saying here. Now, in the next paragraph and following, he sets up then the argument why it is an intrinsic logical necessity that courts will have the power to declare acts of the legislature and executive unconstitutional. And listen to his judicious language. Since he's writing about the judiciary, I guess he has to write judiciously. Some perplexity respecting the rights of the courts to pronounce legislative acts void because contrary to the Constitution has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power or the executive power. And by the way, as you're going to see, from Marbury on, there was some controversy, as you'll see, about the courts possessing this power. Jefferson, as we'll see in our next lecture, was never convinced. Jefferson is the major voice from the founding who opposed the doctrine of judicial review. But after Marbury, as you'll see, and you'll see in Wilson chapter 12, this doctrine that the courts have this power became a pretty settled doctrine. That's not the controversy, as you'll see when we come to the contemporary courts. The controversy is not whether the courts exercise this power, but what the scope, nature, and function of this power is. So Hamilton, interestingly enough, in rejecting the idea that judicial review would make the judiciary the supreme branch over the other two, that would imply judicial dominance or governance of the other two branches, he's mentioning this possibility because he's rejecting it. But nevertheless, interestingly enough, that is the debate in our contemporary judicial universe. It is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. As this doctrine is of great importance in all the American constitutions, a brief discussion of the ground, cannot be unacceptable. We'll come back to this in a minute. So, in the next selection, and I'll come back to this as how to explain it. How does Hamilton build the argument that this is an intrinsic, necessary, implied power of the courts in a written constitution in a system of separation of powers and checks and balances? A little bit further on, I'll read it and then I'll pick it apart and explain it. This exercise of judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in whole or in part with each other, and neither of them containing any repealing clause or expression. In such a case, it is the province of the courts to liquidate and fix their meaning and operation, so far as they can, by any fair construction or interpretation, be reconciled with each other. Reason and law conspire to dictate that this should be done. Where this is impracticable, it becomes a matter of necessity to give effect to one and exclusion to the other. The rule which has obtained in the courts for determining their relative validity is that the last in order of time shall be preferred to the first. But this is a mere rule of construction or interpretation, not derived from any positive law, but from the nature and reason of the thing. It is a rule not enjoined upon the courts by legislative provision, but adopted by themselves, the courts, as consonant to truth and propriety, for the direction of their conduct as interpreters of the law. They thought it reasonable that between the interfering acts of an equal authority, that which was the last indication of its will should be preference. So this is the way how he built this argument. If you're looking at the notes, a court may have to decide which law is valid in applying a law to a case from the same legislature, say from the legislature of a state. When the legislature passes a law that conflicts with prior law but forgets to repeal the prior law, in such an instance, the court usually declares the later law that the later law supersedes or nullifies the prior law. Now, let's be clear, make sure you understand what he's talking about here. And this will be important for Marbury, maybe Madison, in our next lecture. The function of the court is to decide cases. The standards for deciding the cases that the judges apply in cases comes from the legislature that writes the laws. Now, it may be, and typically is, by the way, that different laws apply to the same case. Let's say you rob a bank, and in doing so you murder the cashier. Don't try this at home. I'm not recommending that you do an experiment in this. But in which case you would have violated two laws because you committed two crimes at the same time. You robbed and you murdered. So different state statutes would be applied to that case. And here's what Hamilton is saying. Let's even create an example. Let's say for bank robbery, the court 100 years, the state of South Carolina, the legislature passed a law saying that the sentence for aggravated bank robbery was 10 years in prison. But South Carolina being the state that it is, where it's customary for people to drive around with shotguns and open bottles of whiskeys in the back seat, I know because I'm a resident of South Carolina, even though I live in North Carolina. But let's say that upon consideration, by 2021, the rate of bank robbery has gotten so bad that they they pass a law extending the sentence to 20 years, but they forget, or because I have to say, legislators, especially in state legislatures, they're not always the yellow crayon in the box, as one of my students was used as an expression. Legislatures are busy things. They're elected for short terms in the state legislature. Typically, though, most state legislatures have a 2-year term, at least the House does, and most state legislative senates in a bicameral legislature have longer terms for the Senate. But the point is, they're elected, they retire, they're defeated in an election, and other peoples replace them, and therefore the institutional memory of a legislature isn't always up to date. It's like what happens when you turn 65. I know that happened to me 3 years ago, I think. Yeah, that's right, I'm 68, I just remembered. So people's, institutions have memory too, or lack of it. Now, you could say, well, wait a minute, aren't all the laws of a state collected into a code? Yes, they are. Although that is the universal practice today. All modern legislatures codify, which is arrange their laws in volumes according to subject, and so they're all listed. And typically, a legislature, when it changes its mind on a subject by passing a new law, does often explicitly repeal a prior statute, but sometimes they don't and they forget. What Hamilton is saying here is that this is not infrequent happening when two laws apply to the same case from the same legislative authority and they conflict with each other. What do? The judge has to decide the case, but now he has two legal standards that don't jive with each other, they don't consist. Hamilton is saying the rule of interpretation, but this is just a rule adopted by the courts for consistency, is to assume that the later law supersedes or nullifies or replaces the earlier law. And hence, in a way, he's saying that if the legislature hasn't remembered and explicitly repealed an earlier law when a later law conflicts with something, then it's the task of the courts to kind of clean up the mess. So the courts have this stabilizing digestive quality, which brings order and consistency when the legislature has failed to do this consistently. But as he points out, this is an assumption. It's a principle of practice, and it makes sense that usually and by the way, you could say this is what most societies accept, like in somebody's personal will. The latest statement of what you want to do with your estate when you die is generally understood to replace. What if you find two copies of a person's will, one dated from 10 years ago and one dated from yesterday, and he was killed in a car accident today, God forbid? Well, you assume that the statement of his will from yesterday is the one that should guide you. It's the later one that replaces the earlier one. Okay, that's common sense. And that's so, but this is in the first case where two laws of a legislature of the same authority apply to a particular case. So let's go on to continue in the next paragraph. But in regard to the interfering or conflicting acts of a superior and subordinate legislature, one of original and derivative power, the nature of the reason of thing indicate the converse of that rule, as proper to be followed. They teach us that the prior act of a superior authority ought to be preferred to the subsequent act of an inferior and subordinate authority, and that accordingly, whenever a particular statute contravenes the Constitution, it will be the duty of the judicial tribunals to adhere to the latter and disregard the former. Let's make sure, because in this last paragraph, he's actually blended two different instances, two different examples. But let's start with the first one that's in the beginning of the sentence and interpret that and apply it. He's saying that when you have then in a court in which you have a case and the judge has to decide the case, and two laws apply to the same case, but now one law comes from an inferior authority, whether it's a county and you're talking about a state legislature, or given Article 6 and the experience under the Articles and the Constitution, what you're really talking is, in Article 6 it says, whenever a provision of a state, to back up, in Article 6, which is, if you remember, it's called the Supremacy Clause, it says, this Constitution and all laws of the United States pursuant thereof, and all treaties of the United States, shall be the supreme law of the land, and anything in any state law or constitution shall be null and void. And here he's explaining what that means. If the laws of Congress, let's say regulating commerce, here's an example. It's not quite, I'm going to fudge the details just so you get the point. But you've seen when driving on the interstate highway system, these big double semi-trailer trucks, huge. The state of Iowa passed a law because it's clear that these double-chambered trucks, semi-trailer trucks, are harder on the roads. So Iowa passed a statute that said no double-trailer trucks can be applied to Iowa highways. But Congress, the national government, superseded that because that would mean, in other words, because Congress has the power to regulate commerce among the states, remember, from Article 1, Section 8. And if you were driving a semi-trailer truck, I live in the Quad Cities, my parents live here, and I-80 is the main horizontal interstate that goes from east to west coast, Main Street USA, as it likes to say. And that would mean that a semi-trailer truck coming from New York to San Francisco would have to go around the state of Iowa rather than continue on I-80, and that would substantially impede commerce, the flow of commerce. So Hamilton is saying, if you're a trucker and you want to be able to drive through Iowa because it just costs too much, what you would do is you go to a federal court or even a state court, but a federal court, and here the judge deciding your case would have two laws, one of Iowa and one of Congress. Well, what one should prevail? Obviously, the Constitution intends for the judge to apply the law of Congress as the superior law and negate and declare null and void the law of the state, which is the inferior authority. That's not controversial. But here's where Hamilton then pushes through to the conclusion about judicial review. He says that, but what if the superior authority is the Constitution? After all, the Supremacy Clause says, and you're going to see Marshall in Marbury v. Madison in our next lecture, takes advantage of this language. It says, this Constitution and all laws of the United States pursuant to it shall be the supreme law of the land and treaties of the United States. So the implication is, well, first of all, the Constitution says it's a law. And Article 3 says you can apply the Constitution in cases, as you'll see. So if you have a law of Congress, which applies to a case, and a provision of the Constitution, which applies to a case, and you're the judge and you have to render a decision in that case, which standard are you going to presume governs the case? It has to be the one from the superior authority. Why is the Constitution the superior authority to Congress? Because where does Congress get its authority? Article 1, Section 1, the vesting clause. And so if Congress acts in a way that's inconsistent with its grant of authority in the Constitution, all Hamilton is saying, QED, quaestio est demonstrandum, or quid est, is erat demonstrandum. Sorry, my Latin was I misquoted myself. Don't ever misquote yourself. It has to be. Judicial review in this case is a logical deduction of the function of a court. When two conflicting statutes, one, in this case, the Constitution, and in the other case, a law of Congress, and that is, in fact, his conclusion from the notes. When a provision of the Constitution applies to a case and a federal law applies to a case, the court, the federal judiciary, has to prefer the Constitution to declare the law of Congress void. Voila! Judicial review. So this is, he's saying, is the only way that a limited government, you need judicial review in a written constitution that limits the powers of government. And as you'll see, Marbury essentially repeats this argument. Now, there's one other important thing that Hamilton adds in this essay, and that becomes critical for the way that we understand the way the court functions today. And as you'll see, it's this last point that somewhat leads to the controversies about the scope and nature of judicial review and the function of the courts in our system, that controversy which we see immediately in front of us right now. Let me read from a little bit further on. This independence of the judges is equally requisite to guard the Constitution and the rights of individuals from the effects of those ill humors which the arts of designing men, demagogues, flatterers, or the influence of particular conjunctures sometimes disseminate among the people themselves, and which, though they speedily give place to better information and more deliberate reflection, have a tendency in the meantime to occasion dangerous information and more deliberate innovations in the government and serious oppressions of the minor party in the community. Though I trust the friends of the proposed Constitution will never concur with its enemies in questioning that fundamental principle of Republican government which admits the rights of the people to alter or abolish the established Constitution whenever they find it inconsistent with their happiness, yet it is not to be inferred from this principle that the representatives of the people, whenever a momentary inclination happens to lay hold of a majority of their constituents, incompatible with the provisions of the existing Constitution, would, on that account, be justifiable in a violation of those provisions. So Hamilton is making a point that the judges have an important role in a limited constitution in a democratic republic, because sometimes it isn't just the legislature that wants to screw things up and take over, or the executive. It's the people, and this is where Hamilton is taking a fundamental point from Federalist 10, from Madison. Sometimes the people are tyrannical, and a majority will take away the rights of individuals and of a minority. And the particular independence of the courts, then, is critical in keeping the constitutional system stable and limited against sometimes a democratic opinion, a majority opinion, and in protecting the minority and the rights of individuals against an oppressive majority, bearing in mind that democratic majorities can be irrational, impulsive, and ill-informed, and factional. That's all Federalist 10 right here. You gotta have courts of unique, stable independence, and with the power of judicial review to protect individuals and minorities against an oppressive majority. Remember, democracy is not necessarily a just form of government. And so a constitutional republic, and to conclude here, Hamilton is saying, requires a firm, stable, and independent judiciary to protect itself against the other two branches, and also to protect the constitutional system against the other two branches, and also to protect the constitutional system against inappropriate majoritarian impulses, and finally, to protect the rights of individuals and minorities against an oppressive majority. Because don't forget, and let's take this argument back to fundamentals, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, among which are life, liberty, and the pursuit of happiness. And to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Hamilton brings the core principles of the purpose of government as articulated in the Declaration of Independence and applies it to this institutional question about the scope and nature of the judiciary. So that is Hamilton's argument about the function of a judiciary in a written constitution and a constitutional republic. And as we'll see, it is this argument that Chief Justice Marshall adopts in Marbury v. Madison in our next lecture, and it's just this very point that Jefferson disagrees with, as you'll see in our next discussion.